The point is simple. Do not rely on email alone to move money. And from an insurance standpoint, law firms should review their coverage before a loss occurs, not after. You want to know whether your cyber policy addresses social engineering fraud. You want to understand whether you have crime coverage that may apply. You want to know if there are sublimits, exclusions, or conditions that could affect the claim. And you want to make sure your internal procedures line up with what the policy expects. Because a firm can suffer a very real financial loss and still find out that the coverage it thought it had is either limited or unavailable. That is a very unpleasant way to learn how your insurance works. The takeaway here is straightforward. If your law firm handles money, trust accounts, settlements, or wire transfers, do not assume that wire fraud is automatically covered just because you have a cyber policy. Review the coverage, understand the limits and conditions, and make sure your procedures are strong enough to reduce the chance of the loss happening in the first place. Because when it comes to wire fraud, the question is not only whether your firm can prevent it, the question is whether your insurance will actually respond if prevention fails. Have any questions about your coverage? Give me a call and we can review it. Thanks for listening, and remember, I'm Don I, your insurance guy.